We're on the record, case number 12 CF 1083A, State versus George Zimmerman. Can counsel approach for just one brief moment? Okay, let me know when you're ready.
My approach, just to handle what's in case law, I've got to separate it out from side.
Okay. Thank you.
Thank you, Your Honor.
Okay, thank you. When you're ready to proceed, you may do so.
Procedurally, the objection is Mr. O'Mara's, the evidence is mine, so.
Sure. I objected on the grounds of relevance, and I think the state would now need to show the relevance
Okay.
of the evidence. I could frame it more, but I think the state needs to present why they think it's relevant.
Somebody start.
I'll be happy to, Your Honor.
Thank you.
For starters, I'll point out that the evidence was already admitted. I can't imagine anything more relevant than the fact that it's already before the jury and been partially published. I also can't imagine anything, very few things anyway, more likely to confuse the jury than to stipulate to an exhibit, admit it, publish it, and then attempt to unring that bell. I will simply reference an earlier sort of example of this. We did have on one occasion a juror who had been agreed to be excused for cause, and then the cause evaporated, and the court again said, look, it's already been done, we're not going to go back, even though there really isn't any prejudice demonstrated. It was literally overnight. So I'm going to start with that. Secondly, the issue of relevance. Number one, the state is a little bit uncomfortable sort of giving off a preview just in response to a simple relevance objection, but in this case, the court will hear additional evidence. You will hear evidence about the defendant's neighborhood watch training. You will hear evidence about his prior activities in connection with that, as well as just his prior activities in the community. Some of that is these calls, representative. You will hear about his coursework and how he's been educated. You will hear evidence about his emails to some of his professors regarding his goals for his training. And several of these calls specifically are relevant because, just like the defendant in the call that's already been admitted and played through witness Novke, references people perhaps escaping through the back entrance to the complex and getting away, and he specifically directs officers to go there and worries that these suspicious persons will perhaps get away. The relevance is discussed, legally speaking, section 90.401 and 90.402. And it's important, I think, to parse those phrases. It is evidence tending to prove or disprove any material fact. It doesn't mean it has to prove necessarily an element of the crime. It doesn't necessarily mean it has to prove an element of a defense. Those aren't the only facts in issue, and I would submit that the defenses, both opening and cross-examination, have made several facts in issue, in addition to simply the elements of a crime, a defense, or state of mind in general. I'm going to start with, however, the elements of the crime. and I've given the court the Wimberley case. The Wimberley case was actually a first-degree murder case. Here we have second degree, but in that case the court was very clear, and it's the last page of the opinion. Cases where the defendants used, and in that case it was actually a racial slur as opposed to simply just a conversation with a police officer, relevant to show the defendant's state of mind as an element of the crime charged. Second-degree murder requires, of course, that the state establish an element of ill will, evil intent, spite, those sorts of things. In that case, the court held that because of the charge, in that case attempted first-degree murder, requiring the state to prove a state of mind, in that case premeditation, that the phrase in question or the evidence in question, the statement by the defendant in question, was relevant to establish an element of the crime charged. The reason I bring this up is because there was some confusion, I think, yesterday regarding the distinction between state of mind as an element of a crime and state of mind as a hearsay exception. And the two things are pretty different, and they're treated differently under the law. So I wanted to first introduce the Wimberley idea that anything that is relevant to establish or prove or disprove the defendant's state of mind meets the definition of relevance. I will also point out that although it is different than the 803.3 hearsay exception for state of mind, that this evidence was admitted as a business record under 803(6). So there's an independent hearsay exception. State of mind exception might be useful and might be something that the court can consider in this situation, but it's not necessary for the admission of the evidence. The admission of the evidence is a business record, and its relevance is established by the fact that it relates to an element of the crime. I will point out that that is the same hearsay exception, 803.3, state of mind exception, which the defense yesterday moved the court to invoke to admit certain statements of the defendant in a completely different context. I will also point out that relevance can be to establish an element of a defense. In this case, the defense is self-defense. Obviously, the state has the burden of establishing that this is also not self-defense. The jury's been so instructed already. It will also include whether or not the defendant provoked the incident, provoked the contact. And I point out I guess it's below, Billeaud case, which should be the next one. Evidence is relevant, and this is also on the last page of that opinion, if it tends to prove material fact. In this case, in the below case, the evidence was of extramarital affairs, and it tended to prove material fact central to the self-defense, the straw that broke the camel's back theory. And frankly, that's certainly one theory that bears a strong resemblance to this case, that this is an ongoing building up generalized frustration as expressed by the defendant himself with his remarks about these assholes always getting away. It is error to deny the admission of evidence in that case. In that case, it was the defendant who wanted to offer it. It was central to his theory, and there was no prejudice shown by its admission. I'm still waiting for any showing of prejudice to the defense as a result of the admission of this evidence. And the excluded evidence, the court said, could have significantly strengthened, in that case, it was the defendant's theory. But certainly the same would hold true if it's the state's theory. So an element of defense, in this case, self-defense. Jury instruction 7.4 makes very clear, and the court has already actually in part read this to the jury, it's the homicide instruction. An act includes a series of related actions. Why a particular set of steps? And so the jury is going to be encouraged and should consider the entire context of this. And so the reason that the defendant takes particular steps and prior steps that he has taken, which might be related, certainly should be admissible. Other facts in evidence, other facts in issue, I should say. Number one, motive, and as I've already said, state of mind. I provided the Hart case to the court, and it's the necessary language, or the language I'm relying upon is on the first page in the second column. Motive and intent are states of mind usually inferred from the conduct of the parties and the surrounding circumstances. They are questions for the trier of fact that are generally, in this case it was a motion to dismiss, but we're talking about the bare relevance of this testimony. Motive and state of mind are classic jury questions, and the jury has a right to hear evidence that might relate to establishing those things. In this case, we've heard about profiling. as a state of mind, and the motive for seeking out this particular individual as opposed to prior calls where the defendant did not follow the individuals. There is the issue of whether or not this was, as the defense stated in their opening, simply a concerned citizen, or whether, as the witness stated yesterday, this is evidence of hostility. There is a fact and issue as to whether the defendant merely observed or actually profiled and did more. I will point out that the first words on the non-emergency call that has already been admitted, the call to Mr. Nofke, the defendant says, yeah, there's a real suspicious guy. And his second phrase is about prior break-ins. I think the states should be allowed to establish through relevant evidence like the prior calls whether or not the defendant's allegation that he's suspicious simply because he's walking around in the rain is one thing, or if he considers a lot of other things to be suspicious in and of themselves. So it's the credibility of his comments. The second phrase, the prior break-ins, is it suspicious because he's had prior break-ins, or is it suspicious simply for some other reason? Those are facts that the defendant himself has placed in issue. Again, another fact and issue, why he follows this particular person. And again, it's because these other assholes, and he's describing these other calls as other people, always get away. And actually, I'll give a little preview of the evidence, that two of the calls, two of the reports, indicate that the police actually contacted someone, ran their names, and let them go. What is the impact of these prior incidents on the defendant? That is why I provided the court with the Eugene case, which is the next one in. And this should be on page 4 of the opinion, beginning under head notes 2 and 3 discussion. A statement may be offered to prove a variety of things besides just the truth. When a statement isn't offered for the truth of its contents, but to prove some other material issue, it's not even hearsay. And one of those recognized exceptions is to show motive. They continue on in the next column. The statements they concluded in that case were non-hearsay because they established both knowledge and motive rather than establishing the factual truth of the context. They show, at the bottom of that paragraph, the effect it has on the hearer, the impact on the listener's or the person's state of mind. That is exactly the reason that the state is proffering these prior calls. It's the impact of these prior incidents on the defendant's state of mind. We're going back again. Some calls within about anywhere between 2 weeks and 6 months prior to show the building level of frustration this defendant had with calling about suspicious people, not following them, and having them get away. He even, again, as I mentioned earlier, repeatedly references the back entrance to the apartment complex. He also, in each of these cases, in some of these calls, has specific knowledge of addresses in front of which these suspicious people are. So again, the idea that the defense has placed an issue about whether or not he knows addresses, I think, is a fair fact that makes these calls relevant. In an opening statement, we heard that he purchased his gun simply to shoot his neighbor's dog. I think that is now a fact and issue as to the reason that he actually purchased the gun in the first place. Other facts and issue. The cross-examination of Mr. Nofke implied that the defendant might have only followed a supposed suggestion by Mr. Nofke to get more information and how Mr. Zimmerman would reasonably have interpreted those words. The fact that he has called these number of occasions prior and understands the language of dispatchers and has had these prior interactions, I think is now relevant to establish that that construction of a suggestion by Mr. Nofke that a defendant might interpret it that way when he has never interpreted it that way before, now I think is a fact and issue making those calls relevant. He is not a naive caller. Finally, the admissibility of this. It is admissible in its own right as a valid business record. I will point out that the final theory, and this is represented by the next few cases in the stack, is that this is actually evidence that's kind of intertwined with what's going on, and I've sort of alluded to this already. I'm going to start with the Cameron Holmes case. And in that case, we're talking about, again, a murder charge where the defendant had engaged in some prior drug sales and went back on a later date to collect from the scene and ended up shooting another person who was unrelated to the person that he had sold drugs to. In other words, that he himself created that scenario. In this case, the Holmes court said, typically there's 3 reasons that you can admit such type of evidence. 1, it's necessary to establish the entire context out of which the charged crime arose. 2, necessary to provide an intelligent account of the crime charged. And 3, necessary to adequately describe the events leading up to the crimes. To prove its case, the state is entitled to present evidence which paints an accurate picture of the events surrounding the crime charged. That is exactly the reason that the state believes that this evidence ought to be admitted. It ought to be admitted because it shows the context in which the defendant actually sought out his encounter with Trayvon Martin on the night of February 26, 2012. The evidence, the Holmes court went on to say in the right-hand column, and I'm reading from page 3. Sorry, I should have directed the court. The evidence which appellant sought to exclude showed a continuing chain of chronological events without which an intelligent account of the criminal episode could not have been given and was necessary for the state to be able to show the appellant's state of mind. They continue to say, although this evidence was prejudicial to the appellant, almost all evidence introduced by the state in a criminal prosecution is prejudicial to the defense. Appellant's credibility was at the heart of this case, and it would have prevented the state from fairly and adequately making its case against appellant if the evidence was excluded. That is squarely the situation we have in this case. I would also point out that the defendant himself created these calls. He created these tapes. He created the situation. He's essentially responsible for everything that has been admitted so far. It's him that picks up the phone and makes these statements. So he shouldn't be allowed to complain about it. The Vail case and the Alford case, which are the next 2, kind of relate to my prior Holmes argument. Vail case, the last page of the opinion, again, the evidence inextricably intertwined with the observations and investigations the police held before and during the arrest, relevant to the defendant's admissions after his arrest. The sudden turnaround in his statements, the admission of guilt, confused the jury. Evidence of a collateral crime even, necessary to establish the context of events and to describe the investigation leading up to the arrest and subsequent confessions. So again, we're talking about assisting in establishing context of a homicide here. The Alford case is a little bit older. It's from 1975, but the premise is essentially the same, and the operant language is essentially found throughout. In other words, this is evidence that's relevant to establish context and other things. It doesn't have to be solely relevant to prove an element of the crime. These are other facts in issue. I'm going to move on next to the idea that the defendant himself created these calls, and this is the Jones and Adams case, both of which cite an older case called Mardoff. In the Jones case, it's a single-page opinion, and I'm reading from the right-hand column. In this case, we're talking about more evidence, and in this case, it was an inflammatory type of photograph. But they said it was relevant to the issue of the identity of the deceased, the defense, in this case, the defense of suicide, and the cause of death. They quote the Mardoff case, where they said it is not a valid objection to the admissibility, in that case of photographs, that they tend to prejudice the jury. Competent material evidence should not be excluded merely because it may have a tendency to cause an influence beyond the strict limits for which it's admissible. And they go on to give yet another quote, which I think is apropos for this case. The defendant could not complain because of the shocking nature when the horrible scene disclosed was one which he himself created. That's Jones. Adams also cites it essentially with similar language. So from the state's perspective, Your Honor, the evidence is admissible because it relates to an element of the crime. It relates to a potential defense. It is relevant to a number of items which are now in issue, some of which have been all along, some of which have more recently become so. And it's already been admitted, and there shouldn't be sort of a let's try and take it back. So the state's position is that the evidence is clearly relevant to all those things. Therefore, the relevance objection should be overruled.
Thank you. Mr. O'Mara?
Yes, if I might. We certainly agree that 401 talks about if it's relevant, it's admissible, as does 402. But the reality in this case is that's not the focus of the evidence code. What they're trying to do, now that I see what they're trying to get in, I was curious as to how they were going to relate that to some issue, and now at least I see their point. This is traditional 404 evidence. What they're trying to do, forget the fact for a moment that the evidence is not bad act evidence, because normally 404, you're trying to get in something that the defendant did poorly or badly in the back to say he acted badly then, he acts badly now. But nonetheless, it is previous acts, Mr. Mantai's own words, previous activities of the client. This is traditional 404-2 evidence, which in effect is an attempt to bring in similar fact evidence. Client acted in a certain way back there, and therefore you should be able to let it in now. Well, a couple of things with 404-2. And let me start with my initial response to their opening suggestion that we waived it. If, in fact, there is a concern in this court's mind that it's been waived, maybe the first one, that should fall on counsel. Into the future, that should not affect my client's right to a fair trial with evidence which would otherwise not be admissible, but for a handwritten stip to try and avoid the necessity of putting in photographs and other pieces of evidence. But having said that, if we really do an analysis of the evidence code, we have to look at what the state is trying to do. We know now from their voir dire that they have little, if any, direct evidence to support second-degree murder. Argument, yes, but it seems as though they're presenting that this is going to be a circumstantial evidence case. And their circumstance now, we know, is going to include some prior acts of Mr. Zimmerman, who in the past has called and said, think there's something going on here. Primarily, I think you need to listen to all of the calls to determine whether or not what I just said to you is accurate and whether or not they would fall in under 404-2 prior bad acts, if they're bad acts, or if they're just not relevant because they aren't even properly noticed. Because, of course, under 404-2, if it's in fact similar fact evidence that they're trying to get in, they would have to have noticed this 10 days before trial. We would have had a hearing on that. We would have vetted through much better than we're doing today the idea of why that evidence ever becomes relevant to the court. Because if in fact you were to allow this evidence, if it is in fact relevant, then what is it relevant to? State of mind. To get to, under the state's theory, ill will, hatred, second-degree murder, the element of second-degree murder that makes an act a crime. If you were to listen to these tapes, and I truly think we're going to have the time for you to do so to understand the validity of this argument, those are not acts which show ill will, hatred, second degree. What they show you, what they would show you, is he was acting fine. He called up my wife. There was a burglary here. My wife just saw someone pass by, and here's a description. Oh, there's some kids out there. I don't know who they are, whatever. In effect, what the state is going to show the jury, if you allow that evidence, is 4, 5, or 6 acts where my client has contacted the police to say, hey, come check it out. None of which is going to show ill will, hatred, spite, second degree. Then what they're going to do is say, aha, remember we told you about profiling? Well, now we want you to presume that when he acted reasonably those 5 or 6 times, he was seething under the surface. He was just building up. They talk about evidence and say this is similar to affair evidence. So he was having an affair for the last year. So the fact that he came and killed somebody, the affair evidence is relevant because it shows the bad act. It shows the seething nature of his activity. This is like arguing that he was sleeping with his wife in a rape case. There's no connection. What they're asking you to do by admitting the evidence and then going to ask the jury to do under 404 is to take those prior acts and to presume that he acted in a bad way. We can't see it. The facts, the evidence they're going to admit, if you allow it, doesn't show ill will, hatred, bad act, or anything under 404-2. and I'll go over the case law in a minute, that suggest that that would get in against the defendant. What they're trying to do is show 6 prior acts where he calls the cops responsibly and argue to the jury circumstantially that he is, I don't know, too responsible or too good in calling the cops. So that's the context of what it is that they're trying to get in. Now let's look at some of the case law that I presented to you, and it's quite instructive as far as what you have to do when looking at whether or not any prior act of my client should come into evidence. Anything outside of the 7 or 8 minutes, February 26th, 2012, starting at about 7 p.m. that night. If we're going to go backwards in time and say, let us look at 5 or 6 prior calls of the defendant so that we can argue that we want you to presume some bad behavior, at the very least, Your Honor, I would ask that we not allow it in at this point until the state shows you the connectivity, the connection that they have to make. They can't just argue it to a jury. They have to have some evidence to say to you, now we've shown George Zimmerman as this whatever they're going to show. And now this evidence is now relevant because we have the seething phone calls. They don't have any of that. They're going to be asking this jury to make a quantum leap from good, responsible citizen behavior to seething anger. Not the least of which we can't forget, the only person who's testified in this courtroom so far about my client's behavior, the seething nature of it, or actually the non-seething nature of it, is the one who was talking to him on the phone, Mr. Nofke, who said, I heard nothing. I heard the words, didn't mean anything to me. Didn't raise my spidey sense at all. Didn't make me think about anything except routine phone call. Never even got to level 2 on his little cheat sheet as to what it was. So let's look at the case law to see whether or not this evidence rises to the level, ignoring for a moment the procedural difficulty with the fact that if it is in fact similar fact evidence, which is the only reason why it should come in, Williams' rule is a generic term. 4042 is the evidence code, and what it says is you have to have 10 days notice. But putting that aside for just a moment, let's just say that we were in a Williams rule hearing pre-trial and they properly noticed it. I think it's fatal that they did not, and I'm not waiving that, but just to argue the substance rather than the procedure, let's look at some of the cases that talk about similar fact evidence. One, it has to be so similar in fact that it assists the jury. So if these phone calls, which is why I mentioned a moment ago, you really may have to listen to them. If these phone calls were something that evidenced, I'm using the generic term, seething behavior, anger, animosity, ill will, hatred. If, in fact, those calls evidenced that, then the state might be in a slightly better position to argue to you, Judge, he might have been more subtle with phone call that we have, but this is who he is. Listen to the ill will here. Listen to the hatred there, and then maybe argue to the jury, it continued. He was just more subtle this time. But the 404B, 404-2 truly says it's got to be very similar. And the reason for that is we know under 404-1, that evidence of his character, which is really what they're trying to do, his character is at issue. They can say state of mind, but it's character. It's who he is and how he acted in conformity with that state of mind or that character. And we know that that's not admissible usually, and it's never admissible by the state under 404-1 unless we put it in issue. So 404-1 says evidence of a person's character or trait of character is inadmissible to prove action in conformity with it on a particular occasion, so which is, I guess, in a bizarro kind of way, what they're trying to say, because they don't have bad act evidence, they just have good act evidence that they're trying to say, look between the lines, circumstantially look between the lines. 404-1, except character of accused, evidence of a pertinent trait of character offered by an accused comes into evidence. If we decide that we raise it and have the ability to, from an evidentiary standpoint. or by the prosecution to rebut that trait. So under 404.1, if they're going to try to get it in, then they would have to have it as a rebuttal to a trait that we would first present, and they can say, here's some bad character evidence because he made his character good. Again, well too premature at this point because we haven't put anything at issue yet. We haven't begun our case.
Let me ask you this. Comments in an opening statement create an issue in the case?
No, it's not evidence.
Well, I know it's not evidence, but does it create an issue?
You're going to tell the judge, you're going to tell the jury to ignore it, and the instructions say ignore it. And we have great leeway, and certainly in this case there was great leeway with emotion and with fact, none of which was anything but supposedly a roadmap for where they were both going. So it's not evidence. And if, in fact, it becomes evidence, if there's something in this courtroom that says now it's relevant, then it's admissible. But I don't think that opening statements have now opened the parameters of the evidence code. So,
what about cross-examination of Mr. Nofke?
That's evidence.
Right.
Sure.
So does that create an issue?
Well, let me follow through in my mind what I think you're saying. The fact that Mr. Nofke says that there was no animosity in his voice, does that create an issue? Is that sort of an inquiry?
Well, I'd have to go back and listen to the entire testimony, but did it create an issue on the cross-examination that how Mr. Zimmerman was acting and the interpretation of what the instructions were given to him by Mr. Nofke, does that create an issue?
Let's presume for a moment it does. I hear what you're saying. I don't think it opens up an issue such that the state can bring in 404.2 evidence that they haven't properly noticed that is not proper similar fact evidence. They can't just say now everything's relevant so we can start talking about his past. Let's not forget that if we go into Mr. Zimmerman's past on these 6 events, suggesting, and again, I'm presuming that you will agree that my rendition of the facts is accurate just for this argument. If, in fact, those calls show proper behavior, no ill will within them, then we have now just opened up Mr. Zimmerman's history for rebuttal of the, I guess, presumed under the surface ill will and hatred that you're not going to hear in the calls themselves. You're not hearing the words. So now, are they now making, improperly into 404.1, his character an issue? I think at the very least, we have to put it in issue first into 404.1. But, and I don't want to shotgun approach the 404 argument to...
That's my question. Did you put it in issue in the cross-examination of Mr. Nofke?
By saying he didn't act aggressively, let's say. He didn't...
Well, there are other questions, and I don't want to misquote the testimony, so I'd rather go back and listen to it.
Okay, let's say this. Let's say we did, just for this portion of the argument, let's say that we put in issue that he did not act in an aggressive way or that he followed Mr. Nofke's lead in getting out of the car, whatever it might be. Then, okay, if it's an issue, they still have to follow the proper evidence code to get it in. So within the context of what happened on February 26th, absolutely, that's going to be wide open. Once they go back in time, we then still have to look at 404. That doesn't open the door to make everything that Mr. Zimmerman done in his life relevant. I would imagine that would not be your ruling. So if, in fact, it even suggests that we have to look at Mr. Zimmerman's, what he did. Did he follow Mr. Nofke's suggestions or instructions? Or at least I said he wasn't acting hostile, was he? And that's now at issue. They still have to follow the evidence code. So if they're going to...
I'm thinking that, and again, I'm not quoting because I haven't gone back and listened to the tape, but I think I recall that there was a question of Mr. Nofke of how something he said may have been misinterpreted by Mr. Zimmerman. Therefore, Mr. Zimmerman acted in that way.
Absolutely. So. I think the question was this, and I said, so when you said, what's he doing next, twice, or where is he running to, do you think that could have been, wasn't as artfully done today, hopefully it was done yesterday, do you think that he may have interpreted that as an instruction by you to go find out? That's, I think, what you're talking about?
Yes.
Okay. Let's say that's an issue. I'm not arguing the point that it's not an issue as much as I'm arguing the point of the procedure that has to be followed in order to get relevant evidence before this jury.
I understand where you're coming from.
Okay.
Just...
So as we look at the cases like Thompson versus State, Johnson versus State, first of all, it has to be similar crime or fact evidence. And there is not, let me say it this way, there is not a case that we have found, and I challenge the state to present one, where prior acts of good acts, prior good behavior, is ever presented to a jury for purposes of showing motive, bias, and whatnot.
What I have to sort out is that basically both arguments are apples and oranges. You're arguing Williams' rule, and they're arguing 803.
Okay, I think they're arguing.
And I'm familiar with both of them, but I need to make a decision as to what portion of the evidence code applies here. So I do understand both arguments, and you may go on with that.
To be clear, they're not arguing that this is a hearsay exception. They're arguing business records, but I think
they're not arguing Williams' rule.
Right. What they're saying is it's relevant. And what I have said is, no, it's not.
I understand you, so let's go through the cases.
So if we go through some of the cases, what all of these cases say, and I think what the law in the state of Florida is that the state first procedurally has to give us 10 days notice. But more importantly, the prior act has got to be one that shows the state's case. Makes sense. It has to be relevant to prove a material issue on the state side. So, I feel like I'm arguing the Fry evidence to you again, which is we don't mind the Fry evidence coming in. It's just going to confuse the jury, and it doesn't make any sense. And what I'm saying is I don't mind 6 evidence positions of my client coming in to show he acts responsibly and appropriate to the law. So I should just sit down and let it in and then argue to the jury. That's exactly what he did. There's no evidence to counter that he did that in this case. But the reality is, what I'm saying to you is unless it is absolute relevant evidence to this jury to consider, I don't think it's fair to put in prior good acts because there's no provision under the evidence code.
I understand your argument. I just want to go over the stack of cases.
Let's go over the stack of cases.
Okay, thank you.
All of which suggest prior bad act, and from Johnson versus State to Billy versus State, which is pretty good. Again, we couldn't find any case. I'm going to argue the prior bad acts as though it applies. King versus State, I think, is a good case I would focus you on because what that states is, that was sort of the case of. In that case, the prosecution in a second-degree murder case brought in evidence that the defendant fought with a prior wife. So they sort of said, bad act, he did it then, and we want to show that he had ill will and hatred towards a prior wife. He has ill will and hatred towards this one. And if you look at the analysis in that case is pretty good, and they said, not admissible. Not admissible. Not close enough, not factually specific enough to say even though he may have beaten up a prior wife and is on second-degree murder for this wife, that's not relevant. So it shouldn't get to a jury unless, in fact, the evidence is going to help them decide a material issue. What is the material issue here's the real question. If, in fact, it's relevant, it has to be relevant to a material issue. They want to say state of mind, because that's what they want to get to the jury. But the state of mind that it has to get to is guilt. Presumably, they're not going to prove state of mind of non-guilt, so they want this in for state of mind of guilt. Look at the evidence before you decide and tell me if any of those pieces of evidence, individually or as a whole, evidence guilt. Because if they do, maybe the state has proven their case. My fear is that they're going to try the circumstantial evidence jump over the Grand Canyon to try and get the jury to say, he acted so nicely here, he must have been seething with anger. Finally, he blew up. Well, connect the dots, and maybe they can argue that. Don't connect the dots with prior good acts, because that's what the case I just cited, that's what the King case said. Going forward, the Morejon, M-O-R-E-J-O-N, at 394 Southern 2nd, 1100. If, in fact, in that case, it has to be relevant to the client's state of mind at the time of the event. Nothing of this evidence suggests at all how my client acted at the time of this event. Nothing. And if, in fact, they're going to try and tie those dots together, then they are woefully inadequate today. Maybe after a few more days of state testimony, they can come back with a better argument to suggest to you that, in fact, this should be allowed in to tie up one or two loose ends, but not as substantive evidence to prove ill will without something more. Because today, with the evidence we have to right now, that's all they have. They have nothing, and now they're trying to present a sort of a stealth argument that we want you to believe he's bad because he was so good in the past, he must be angry. And realistically, state of mind, from what I understand it, doesn't negate the rules of evidence. They can't just say state of mind lets everything in. State of mind is their argument. They have to follow 401, 402, 403. And of course, 403 then is one of the gatekeeping rules that we have to say, unless it helps them, we're not going to confuse them. So I would ask the state or you, after looking at the evidence, to consider whether or not evidence of prior good acts is going to confuse this jury rather than help them. And if so, the state should show to you how it does that before we potentially infect this jury with evidence that does not connect up that evidence to the state's case. So there are a lot of cases. I would just say that it's not relevant just because the state says it is. I think they need to present it to you ahead of time. If, in fact, you believe that a 404 analysis is appropriate, you do need to address the issue of the procedural fault on the state. I will tell you that I think the procedural remedy is akin to a Richardson inquiry to see what has happened in their failure to. But substantively, this is just prior act evidence that is not so similar in act or fact that it should be admissible before this court. It's certainly not before the jury.
Okay, thank you. Response?
Thank you. We've had now a bit of a bait and switch and a series of straw men. The objection made yesterday was that it is irrelevant. That was what I've been under the impression we were addressing today. I heard 404. I heard 403. I didn't hear 402. 402 and 401, more specifically, are the relevance sections. That being said, relevance, of course, is a really low hurdle to meet. Bare relevance is often the phrase that we hear. I want to address a few things. Number one, state of mind of guilt and consciousness of guilt have been used interchangeably in terms of their definition by Mr. O'Mara at this point. They're not the same. State of mind of the defendant, in this case, doesn't have to be consciousness that he's guilty of murder. It's an inappropriate phrasing. His state of mind is relevant because that is an element of second-degree murder, ill will, whatever. If I need to spell it out a little further, this is not evidence of good acts. It's not evidence of that sort of thing at all. Nobody is alleging that these are good acts. What the evidence is relevant for is to show that on December 26, 2012, the defendant engaged in a series of acts and a pattern of behavior and a gathering of circumstances. February 26 of 2012, which is very different than he knows he should have behaved and that he has in fact behaved before. The implication, I think the court hit on it squarely, the implication yesterday in the cross-examination of Mr. Nofke was well, he was just kind of misinterpreting and thought maybe you wanted him to go fetch information or follow. And that certainly is belied by the fact that he has had all these prior contacts. So nobody's calling this good act evidence. In fact, what is relevant about it is the fact that you can see that he has, again, on prior occasions, called to report suspicious people, knows how to do that, knows what not to do, and the frustration builds. That frustration is expressed in his non-emergency call on February 26th to Mr. Nofke about these assholes always getting away. It's repeated during his interviews with the police when he again references, I've called before, these guys get away, and in several of the calls, as I said, he specifically references they go out the back entrance, just like in February 26th, 2012. Same direction, same entrance. So its use lies in its comparison. And what is different about this defendant's state of mind on February 26, 2012, having now experienced all this, than it was before? The state has to prove that his state of mind on February 2012 was not good, for lack of a more exact phrase. And that doesn't. It delineates in stark contrast the difference between what he knows to be appropriate behavior and what he did on February 26, 2012, and how he described it. The words, they always get away, those aren't any words but his. And the fact that he said them that night, in that context, makes this relevant evidence. Number two, some kind of allegation that this is 404B or character evidence. 404B is the rule about other crimes, wrongs, or acts. Number one, case that Mr. O'Mara even himself provided, Gardner versus State, says at the very last page, in the very last paragraph, no, that 10-day notice thing isn't absolute anyway, because the only way that lack of notice is prejudicial or isn't harmless is where there's showing of actual prejudice and unfair surprise. In that case, they said they cited the Pale case, which says it's harmless where it's apparent the defendant knew of the evidence and knew of the state's intent to introduce it. He's had this evidence for months. This witness has been listed forever. There's no question about that. So if we want to talk about the actual wording of the rule, let's talk about that. There is no immediate fatality or procedural problem. Heck, they stipulated originally to the admission of the calls. This isn't some secret. Number two, let's briefly reference the 403 standard, which is the prejudicial value and probative. I'm going to point out again, and I'm going to come back eventually to the Holmes opinion, that that's not actually what the rule says. The rule says that the only way that that evidence would be excluded under that subsection is if its probative value is substantially outweighed by the danger of unfair prejudice. That's not been alleged, established, or shown at all. It almost is a concession that there is some probative value here. Finally, Your Honor, I want to talk about 404B because I heard Mr. O'Mara tell the court that it requires that the incidents be strikingly similar or very similar. That's not true either. The only time that is necessary is when the state is offering evidence under 404B to establish the identity of the perpetrator. For any other purpose, there is no similarity requirement whatsoever. For identity purposes, they require it be, I think the phraseology is fingerprint type evidence. So let's if we're going to talk about all these other sections sort of as a surprise, because again, the objection was relevance, nothing else, let's actually quote them correctly. Your Honor, the Holmes opinion is about as close, I think, to on point, and I referenced it before, as we get here. That is, the evidence here isn't 404B anyway. It's not character evidence. It's not other crime, wrong, or act evidence. It's evidence that's inextricably intertwined to show the defendant's reaction to his experiences and why on the night of February 26, 2012, he undertook a series of actions, certain steps. It is evidence which paints an accurate picture of the events surrounding the crime charged adequately describes his deeds, shows a continuing chain of chronological events, and is necessary for the state, or at least helpful for the state, to show the defendant's state of mind. I don't necessarily need to establish his state of mind in August of 2011, or September of 2011, or October of 2011, or earlier in February of 2012. I do need to establish what was in his mind on February 26, 2012, and how we can do that is we show that his actions and behavior that night are very different from his other actions. It's not being offered to prove his character or that he behaved well. It's to show that something happened that changed his mind, that caused him to refer to these assholes always getting away, that caused him to call them punks, that caused him to get out of the car and follow him. That's what makes it relevant. And so to call it 404B evidence is incorrect, it's misleading. If anything, it's inextricably intertwined, which is not required to be governed by 404B. It doesn't require notice, and that is the whole focus of the Holmes opinion, or part of the focus. It is relevant to many issues, not the least of which is the defendant's state of mind. The state also, I want to point out one other thing I want to correct about what we just heard from Mr. Mayor. I'm allowed and required, actually, to establish or to address the self-defense in this case. A fact in issue, relevance, pertains to not just the elements of the crime, but elements of a defense, whether it's justifiable, whether it's provoked by the defendant, and any other fact that has been placed in issue. The defendant's credibility and his statements and his actions are all facts in issue. And for that reason, the state's position is these calls are relevant. How the defense chooses to spin them is not. Thank you.
Both sides have handed me a total of 20 cases this morning that I have just perused, and I'd like to get to look at them even more. And I also want to rehear on the tape the testimony from Mr. Noffke, the directing and cross-examination. Mr. O'Mara has suggested that I listen to the tapes. Oh, okay. Can I get a copy of those? Okay. All of them are on the exhibit?
All those that the state is seeking to introduce. I think we talked, and I know I heard 6 reference. There's 5 that the state has.
And they're all
used.
on that exhibit?
They are all on that exhibit.
Okay. Does the state have another witness you could go forward with today until I have the opportunity to read those?
I actually have 2 alternative suggestions. One, I think we do have another witness, but also Ms. Rumpf isn't just talking about the non-emergency calls. She's also going to be introducing and laying the predicate for the admission of the 911 recordings themselves. I don't think those are nearly as controversial as this has apparently turned out to be. So
Okay.
she could actually continue with her testimony on those matters right now.
Okay. Well, let's go ahead and do that, and then I'll listen to the testimony, the tapes, and after court today, and the case law.
If I might, I just want to make sure, because my understanding is there's a category 6 or 7, and if there were 5 being presented, maybe I didn't know which 5 and which ones aren't being
Well,
presented.
do you want to play them in court as a
As long
proffer?
as I get a copy of what you'll be listening to, I can do it on my own.
Well, so there's no question of what I'm listening to. Do you want to proffer? Okay, let's go ahead and proffer exhibit. Was it on 171 or 172?
I believe it's 171 is the actual recording. 172 is
Okay,
the affiliate report.
let's go ahead and proffer 172.
our neighborhood got burglarized or robbed today, and my wife saw one of the kids that did it, and
just so we're clear, we can keep track. They're playing through, but I'm not certain we don't have context.
Do we have a date?
Date,
Sure.
time.
The calls are as follows. First one is going to be August 3rd, 2012. Second is August 6th, 2012. I'm sorry, 2011, both of those dates. My apologies.
I'm sorry, what?
It's 2011, not 2012. August 3rd, August 6th, September 23rd, 2011, October 1st, 2011, and February 2nd, 2012.
And do you know the time of day?
Not without looking at the reports. I know the first one is about 6:45 p.m. Candidly, I don't remember the exact times on the rest.
Is that indicated on Exhibit 171?
It is. They are, yes.
By date and time?
It's on 172 as far as the,
Okay.
yes.
I just want to make sure that we have an exact copy of what the court's about to listen to that's going to go in, because if that only has 5.
It's already in.
Okay, it may be less than what we have. I just want to know which ones they are. So I'll follow along. We'll figure this out at a break.
Airport Police Department, the line is Cordes, Petra.
hey, our neighborhood got burglarized or robbed today, and my wife saw one of the kids that did it, and we see someone that matches his description in the neighborhood right now again.
Okay, and what's your address out there?
I'd rather not give out my address because he's obviously in the neighborhood, but it's Retreat View Circle. You can use 1111, which is the clubhouse.
Okay, so does he live in the neighborhood, or he's just out walking?
I don't know. It's the first time I've ever seen him.
Okay. And what is your name?
My name is George.
And your last name, George?
Zimmerman.
And your phone
Like
number
I
you're
said,
calling from?
407-435-2400.
Okay. And is he white, black, or Hispanic?
Black.
And what's
My
he
wife
wearing?
talked to Detective Walker and gave him a description of the guy we see now.
Okay. And what's he wearing right now?
A white tank top and black shorts, and brown sandals, and black socks.
Okay. And is he walking?
Yes.
Okay. And so is he near the...
The back entrance to the neighborhood.
So he's at the back entrance?
Yeah.
Just went between the houses.
He just went between the houses to the back?
Yes.
Shoot.
You were looking at your car.
I'm not.
No, you aren't.
Why not?
Don't call.
Okay, we'll get an officer out there, check the area.
Okay, thanks.
You're welcome. My name's recorded. This is Nicole. How can I help you?
Hi, there was a break-in in my neighborhood recently, and 2 youths that matched the description of the people. My wife ID'd them and saw them. They're back in the neighborhood.
What's the address?
You can use 1111 Retreat View Circle, Sanford, Florida, or you know that.
Twin Lake Townhomes?
Yes. Yes.
Okay. And what do they look like? Are they white, black, or Hispanic?
Black males, 2 black males in their late teens. One's wearing a black wife beater, black tank top, and black shorts, and the other one's wearing a black shirt and blue jeans. And they're at the back gate of the neighborhood.
Okay. Approximately how old are they?
Late teens.
Okay. You want to leave your name or number?
I can leave my name and my number, and I'll actually be at the back gate to let the officers in because there's no code there.
What's your name?
It's George, and it's 407-435-2400.
Okay.
If you'll let the officers know, they typically run away quickly, and I think they head over to the neighborhood, the next neighborhood over, so you may want to send the unit over to Calabria Cove.
What's it called?
Calabria Cove.
Okay. Yeah, cool. All right, I'll let them know, and they are on the way, okay?
Okay, thanks.
All right, thank you. Bye-bye. Sanford Police Department, this line is being recorded. This is Vicki.
Hi, Vicki. My name is George, and I live at the Retreat of Twin Lakes subdivision.
Okay.
I'm part of the Neighborhood Watch, and I just wanted to let you guys know that somebody left. We've been plagued with some robberies, burglaries, and somebody did leave their garage door open.
Hold on, sir, 1 second. I've got my units calling me.
Okay.
Hold on. 1512. 10-4, sir, go ahead. 10-4, stand by. Hold on for me just one moment, sir. I apologize.
No problem.
Sanford back to 1512. Reference Justin McKinney. 1029P is 1054. No local. Showing a valid DL out of Manhattan, Kansas. At 2310. Okay, somebody's got their garage door open, you said?
Yes, ma'am. Yes,
Okay, do you know the address of where the garage door is open?
as far as I can tell, because it's poorly lit, I believe it's 2040 Retreat View Circle. Of course, Sanford, Florida.
Okay.
House.
And you said there's been a lot of break-ins there lately?
Yes, ma'am. We actually just had our neighborhood watch meeting yesterday, and Sergeant Herx came out here and Officer Buchanan
Okay.
told us to report anything suspicious, and it's late, and they usually don't have their garage door open all night, so.
Okay, and George, what is your last name?
Zimmerman,
And what's the telephone number in case we need to call you back?
407-435-2400.
Okay, are there any cars in the garage or the driveway just so we can make sure we're going to the right?
Yep, there's in the garage, there's a silver Nissan Xterra.
Okay, we've already got an officer heading that way, sir.
Thank you, ma'am. Have
Sure,
a great
thank
night.
you. You too. Bye-bye.
Bye-bye.
Seminole County. Sanford Police, this line's being recorded. Sharon speaking.
Hi, I was just calling because we've had a lot of break-ins in our neighborhood recently, and I'm on the neighborhood watch. And there's two suspicious characters at the gate of my neighborhood. I've never seen them before. I have no idea what they're doing. They're just hanging out, loitering.
What's the address?
1111 Retreat View Circle. And that's Sanford,
Is that the
Florida.
Twin Lakes townhouses?
Yes, ma'am. No, Retreat at Twin Lakes, yes.
So, yes, that was Twin Lakes townhouses?
Yes, ma'am.
Okay, great. Can I get your name and a callback number?
George, and it's 407-435-2400.
And George, can I get a last name?
Zimmerman.
And Mr. Zimmerman, can you describe the two individuals?
Two African-American males. They looked, I know one was in a white Impala.
How old did they look to you?
Mid to late 20s, early 30s.
They're in a Chevy Impala. Did you get a license plate?
A white, no, it's a white Chevrolet sedan. It's either an Impala or a Lumen of it. I think it's an Impala.
Can you still see them?
No, ma'am. I didn't want to attract attention.
How long ago were they out there?
Just, 10 seconds ago. I just called. I called as soon as I saw.
Okay. All right, we'll send someone out there and see what we can do, okay?
Thank you, ma'am. Have a great night.
You too. Bye-bye. Sanford Police Department, this line's been recorded. This is Renee.
Hey, can I get an officer to 1960 Retreat View Circle?
Your name?
George?
You said 1960?
Yes, 1960.
What's going on there, George?
I'm with the Neighborhood Watch, and we've had some burglaries and vandalisms lately. And this gentleman was walking in the neighborhood. I've seen before on trash days, going around picking up trash. I don't know what his deal is.
Is he white, black, or Hispanic?
It's black.
What is he wearing?
He's wearing a black leather jacket, a black bomber hat.
Black, what kind of hat?
Like a bomber hat, like the ones that have the ears, like
Okay.
that you can fold down.
Black leather jacket, black hat, and what else?
And like flannel printed pajama pants.
And what is he doing?
He keeps going to this guy's house. I know him. I know the resident. He's Caucasian. And he's going up to the house and then going along the side of it and then coming to the street and then going back to the side of it. I don't know what he's doing. I don't want to approach him personally. If you have an officer available, I'd probably have him stop on Reinhardt across the street from Walter Meets Bentley and go around the back.
Okay, George, what's your telephone number you can be reached at?
407-435-2400.
Okay, we'll get one out there. Thanks for calling.
Thanks.
Bye.
That is all fine.
Okay, thank you. I'll go ahead and review the testimony in the case law, and in conjunction with the state's exhibit that they're seeking to introduce, we will readdress this issue later. Right now, if we're ready to bring in the jury and have Ms. Rump continue the testimony on other matters.
If I can have just maybe 5 minutes or so to make sure that I can queue up the different set of calls and things like that.
You want to take a 10-minute recess?
Thank you, Your Honor.
Okay, court will be in recess for 10 minutes.